Ready? Start. This is an appeal under Section 31 of the Armed Forces Tribunal Act 2007, by which an exception has been taken to the judgment and order dated 27th August 2013 passed by the Armed Forces Tribunal, for short, the said Tribunal, Regional Bench, Kochi. Stop. On 31st July 2002, the appellant joined Indian Navy as a sailor. Stop. The appellant was selected by the Service Selection Board to undergo training for being commissioned as an officer. Stop. He underwent initial training at INS Mandovi at Goa for a period of 2 years from 7th July 2002. Stop. On 21st June 2009, he was sent for training at Indian Naval Academy, Azimala, for short INA. Stop. He was required to complete 5th and 6th terms of training at INA. Stop. On 1st December 2010, a communication was issued by the Integrated Headquarters of the Ministry of Defence, Navy, Government of India, informing that the competent authority has accorded approval to the withdrawal of the appellant from INA and revert him to his original rank and branch as a sailor without loss of seniority. Stop. Being aggrieved by the said decision, the appellant filed original application under Section 14 of the Armed Forces Tribunal Act 2007 before the said tribunal. Stop. By impugned judgment, the original application has been dismissed. Stop. Para. The learned senior counsel appearing for the appellant pointed out the order dated 27th August 2013 passed by the said tribunal, by which leave has been granted under subsection 1 of section 31 of the Armed Forces Tribunal Act 2007, as three questions of general public importance were involved. Stop. The first question was whether the appellant, who was a service cadet, could be withdrawn from the course in INA without following the principles of natural justice. The second question was whether Regulation 216 of the Navy Discipline and Miscellaneous Provisions Regulations 1965, for short, the said regulations, could be invoked against a service cadet. Stop. The third question was whether after completion of the course and receipt of the certificates, the applicant could be withdrawn. Stop. Para. The learned senior counsel submitted that the withdrawal of the appellant from the course is contrary to the rules in the enclosure 1 of Naval Headquarters letter dated 11th November 1988, which provide that the final authority for withdrawal of a cadet from the course vests in the government. Stop. He pointed out that in this case, the decision is made not by the government but by a subordinate authority. Stop. He also pointed out that the same enclosure provides that a cadet is to be dispatched home on leave pending the acceptance of the proposal for his withdrawal if it is made on the eve of summer/winter break. Stop. He submitted that even after the recommendation was made for the withdrawal of the appellant from the course, he was not sent home but was permitted to pursue the course. Stop. He also pointed out that the naval authorities have contended on one hand that the withdrawal is on the disciplinary grounds, and on the other hand the withdrawal is on the ground that the appellant was found deficient in basic character and other like qualities and graded as unacceptable in spite of written warnings. Stop. He submitted that both the grounds are distinct grounds. The learned senior counsel further submitted that the officers of the Navy have victimized the appellant due to the fact that he comes from a very poor family and his father is working as a carpenter in a naval establishment.